The handcuff closed around Renee Holloway's left wrist while the judge was still delivering a ruling. Sergeant Daniel Grant drove her shoulder toward the polished courtroom rail and pulled her other arm behind her. Renee caught herself before her face struck the wood. "Stop resisting." "I am not resisting," she said. "The judge's clerk has my authorization." The clerk stood 3 steps away, holding the sealed blue appointment file Renee had presented at the security desk. Grant did not look at it. He tightened the cuffs until a metal edge cut into Renee's forearm, then announced to the crowded gallery that she had entered a restricted area without credentials. Renee heard phones rise behind her. A camera shutter clicked twice, followed by the faint mechanical whir of a broadcast camera near the rear aisle. She had spent 26 years teaching troopers that public authority was measured most clearly when nobody important appeared to be watching. Now, less than an hour before her ceremonial swearing-in as Caro's new state police chief, she was being tested by the same rule. "Sergeant," the clerk said, "she is on Judge Keller's private calendar." Grant glanced at Renee's plain navy suit, silver-rimmed glasses, and visitor badge. "That badge does not put her inside the rail." "The clerk invited me forward," Renee said. "You reached for a sealed court file." "It is my file." Grant turned her sharply. The cuff chain scraped the fresh cut, and warmth slid beneath her sleeve. Several spectators flinched. A white attorney standing inside the same rail remained untouched, his temporary badge hanging backward where no one could read it. Chief Judge Miriam Keller stopped speaking. "What is happening down there?" Grant faced the bench without loosening his grip. "Unauthorized person refused an order to leave, Your Honor." Renee saw the clerk open her mouth. One sentence from Renee could end the mystery. She could state her office, demand that her commission be read into the record, and turn the room's attention toward the confidential briefing hidden inside the blue file. That briefing concerned courthouse security complaints, inflated incident numbers, and people who had been arrested after receiving judicial permission to enter restricted areas. She chose restraint. "Please verify the file before he removes me," Renee said. Grant mistook the request for weakness. "You can explain it downstairs." He pulled her toward the side door. The gallery erupted into overlapping whispers. Someone called her a protester. Another person asked what she had stolen. Renee kept her feet beneath her and fixed her attention on the green exit sign above the corridor, refusing to give Grant the stumble his report might later describe as resistance. The rear courtroom doors opened. Captain Elise Vaughn entered with 4 members of the State Police Transition Command, all in formal charcoal uniforms. They had expected to escort Renee from her judicial meeting to the Capitol. Vaughn's expression changed when she saw blood marking Renee's cuff. "Chief Holloway?" Grant stopped. For the first time, he looked from Renee to the sealed file, then to the command insignia across the officers' collars. Judge Keller rose behind the bench. "Sergeant, do not move her another step." Grant's face drained, but his hand went to his shoulder microphone. Before the clerk or Vaughn could reach him, he pressed the transmit switch. "Control. Send a supervisor to courtroom 4, he said. "I have 1 prisoner in custody for trespass, resisting, and impersonating the state police chief." The radio answered with a burst of static. Then a dispatcher acknowledged Grant's request. The words impersonating the state police chief passed through the courtroom speakers before anyone could correct them. "Release the transmit switch," Judge Keller said. Grant obeyed, but he kept one hand around Renee's upper arm. Captain Vaughn crossed the aisle slowly, careful not to create the confrontation he seemed to expect. "Sergeant, I am Captain Elise Vaughn, commander of the State Police Transition Detail. That is Chief Renee Holloway. Her commission became effective this morning." She displayed her own credential and offered a second leather case containing a certified copy of Renee's appointment. Grant barely glanced at either. "She had no police identification visible," he said. "She was inside a controlled zone and refused commands." "I gave no refusal," Renee said. Grant looked past her. "That is for the report." The answer told Renee more than an apology would have. He was no longer deciding what had happened. He was deciding which version could survive. Judge Keller ordered the gallery to remain seated and directed the clerk to place the blue file in the court safe. She then instructed the court reporter to preserve every word recorded since Renee entered. Grant's jaw tightened at that order. Warren Pike, the courthouse security director, arrived through the side corridor with 2 officers. He was a broad, silver-haired administrator in a suit. Grant spoke first, compressing the encounter into 3 phrases: unauthorized entry, physical resistance, false claim of office. "The claim has been verified," Vaughn said. Pike studied the blood beneath Renee's cuff. "Remove them." Grant inserted the key. The left cuff dragged across the open abrasion before releasing, sending a sharp weakness through Renee's hand. She did not pull away. She watched Grant instead, noting how quickly he closed the cuffs and returned them to his belt without examining the blood. For most of her career, Renee had trusted disciplined silence. As a young trooper, she had learned that anger from a black woman in uniform was remembered longer than the insult that caused it. She had built her authority through preparation, precise language, and a refusal to give careless people anything they could distort. That habit had carried her from night patrol to major crimes command and eventually to the governor's short list. It had also taught her to absorb damage privately. A courthouse medic pressed gauze against her forearm and tested her fingers. Renee could close them, but her grip weakened before the medic finished counting. He recommended immediate treatment and possible sutures. Vaughn leaned close. "The ceremony can wait. We need to get you out through a secured exit." Renee looked toward the blue file. She had come without an escort because the briefing concerned complaints against courthouse security officers. Announcing a command arrival would have warned the people whose records she and Judge Keller planned to examine. Grant's phrase, "controlled zone," had appeared repeatedly in the complaint summaries, usually beside an arrest that prosecutors later declined. "Preserve his radio traffic," Renee told Vaughn. "Do not request his personnel file yet. We follow jurisdiction and notify county counsel first. You are protecting process after he just used it against you." "I am protecting whatever truth is still outside this room." Pike announced that Grant would remain on duty while his office conducted an initial review. Judge Keller objected, but Pike replied that courthouse employment decisions belonged to his department. Grant stood beside him, already speaking quietly into another officer's recorder. The gallery was finally released. Reporters rushed into the corridor, shouting questions about why the new chief had been arrested. Renee declined to answer until the judicial file could be lawfully unsealed. She believed the complete record would catch up before speculation hardened. Her phone vibrated as Vaughn guided her toward the private elevator. The governor's counsel had postponed the ceremony. Beneath that notice was a message from Renee's 17-year-old son, Micah, attached to a frozen image of Grant forcing her over the rail. "Mom, they're saying you pretended to be chief. Tell me what happened." Renee called Micah from the private elevator. She kept the injured arm elevated while Vaughn held the gauze in place. "I did not pretend to be anything," Renee said. "My appointment was verified in the courtroom." "Then why are they showing you in cuffs?" The question landed harder than accusation. Micah had grown up watching her uniform leave the house at impossible hours. She had taught him that a complete record mattered more than the first rumor. At 17, he was old enough to recognize when that lesson failed. "Because I thought the process would correct him," she said. "Did it?" The elevator opened before she could answer. At a nearby clinic, a physician cleaned the crescent-shaped abrasion and closed it with 3 sutures. No tendon was severed, but swelling had weakened her grip. He ordered her to limit use of the hand and return if the numbness spread. Vaughn photographed the injury only after Renee signed the medical release, then transmitted the images to state counsel through the authorized case portal. Grant's report arrived before Renee left the examination room. The county prosecutor's intake unit had received referrals for criminal trespass, resisting detention, attempted removal of a sealed judicial document, and impersonating a public officer. The report stated that Grant had given 3 verbal warnings before touching Renee. It claimed she stepped deeper inside the rail, reached toward the clerk, stiffened both arms, and announced that she was the state police chief only after being restrained. Some details were true enough to carry the false ones. Renee had been inside the rail. She had moved toward the blue file when the clerk raised it. Her arms had become rigid when Grant twisted them behind her. Her commission was not visible, and the private meeting did not appear on the public docket. "He built this for someone who was not in the room," Vaughn said. "For a reviewer reading boxes," Renee replied. "Not for a witness remembering sequence." She noticed another choice. Grant had entered the event as a Category 4 security breach, the highest designation that did not require a weapon. The classification was created 13 minutes after he called for a supervisor and before Pike ordered the cuffs removed. Back at the State Police Transition Office, Renee found the postponed ceremony replaced by a legal briefing. The governor's counsel would not reschedule, while criminal referrals remained pending. State attorneys could request the courtroom record, but Judge Keller had sealed the conference materials and the related audio to protect complainants named in the blue file. County officials immediately argued that nothing inside a sealed integrity review could be used to defend Renee in public. Warren Pike released a statement that afternoon. It praised Grant for treating rank and status equally, described Renee as an unannounced visitor, and promised an impartial internal review. The statement did not mention her blood on the cuffs or Judge Keller's order to stop the removal. Then Pike requested temporary control of all courthouse recordings related to the incident. "He cannot take the court reporter's record," Renee said. "No," State Counsel answered, "but his office controls the corridor cameras, access readers, and security incident platform. He says they are operational records required for his investigation." The public version hardened through the afternoon. A cropped phone video began with Grant saying, "Stop resisting," and ended before Vaughn entered. Commentators asked why a real chief had no badge. The Courthouse Officers Union accused Renee of using her appointment to intimidate a security officer performing routine duties. Vaughn set a printed budget packet beside Renee. It had been among the documents prepared for the judicial briefing, separate from the sealed complaints. Pike was seeking legislative funding for a new courthouse response unit, 12 additional positions, and expanded overtime. His application depended on a claimed surge in restricted zone breaches. Grant had personally recorded 19 of them. Pike's staffing proposal named him as the recommended commander. "If those incidents are downgraded," Vaughn said, "the surge disappears." "And so does his command," Renee replied. Her phone displayed a new county filing. Grant had amended his report. A sentence that originally read "subject did not display identification" now read "subject repeatedly refused to provide identification." The platform showed that the amendment had been approved by Warren Pike. Renee read the amendment twice. The first wording described absence. The second described defiance. Between them stood a conclusion that no new evidence supported. "We preserve both versions," she said. Vaughn had already begun a legal hold request, but state police authority did not extend into Pike's county-operated platform. County counsel acknowledged the request and promised that records would be retained under ordinary policy. They refused to provide an export until Renee formally recused herself from any state involvement in the matter. She signed the recusal before sunset. It was necessary. It also left the newly appointed chief unable to direct her own investigators, view county evidence, or answer accusations with information obtained through her office. Vaughn became acting contact for the transition team, while an outside state inspector was sought. Renee's first command memorandum, which concerned discretionary stops and public identification, was held back to avoid the appearance of retaliation. Grant remained in uniform. Pike moved faster. His office delivered an incident packet to the legislative budget staff reviewing the proposed courthouse response unit. It included Grant's amended report, Renee's visitor badge, a still image of her hand reaching toward the clerk, and the cropped phone video already circulating online. It omitted the certified appointment copy and Judge Keller's command to stop the removal. By evening, A legislative member publicly asked whether Renee's appointment should be reconsidered. The governor did not withdraw it, but the ceremonial oath stayed off the calendar. Renee was legally chief and publicly treated as a question mark. At home, she found Micah at the kitchen table with his laptop closed. The white shirt he had planned to wear to the ceremony still hung from the back of a chair. The anesthetic had worn off. Each pulse drew heat through the stitches, and her fingers trembled when she tried to open a bottle of water. Micah took it from her without comment. That small act made the injury feel less like evidence and more like something Grant had brought into their home. "They slowed the video down at school," he said. "People kept saying you reached for something. I reached toward my appointment file after the clerk raised it. Why didn't you tell him who you were?" Renee set her bandaged arm on the table. "Because the file named people who trusted the judge to keep their complaints confidential. If I announced why I was there, I could have exposed them. You could have said your name. I believed he would verify it." Micah looked at the bandage. "You always tell me not to expect strangers to see me the way you do." She had no answer that would not sound like an exception created for herself. The first break came from Judge Keller's chambers. The confidential briefing remained sealed, but the arrest had occurred during an open proceeding. The judge authorized release of a narrow certified transcript covering the period from Renee's approach to the moment the gallery was cleared. She assigned official court reporter Lena Ortiz to prepare it under judicial custody. Lena called Renee only after notifying all counsel. Her voice was careful. "I cannot discuss the sealed material," she said. "I can tell you the public session transcript is complete. Does it contain 3 warnings from Sergeant Grant? The record will speak for itself." The certified pages arrived 40 minutes later. The transcript captured the clerk, telling Grant that Renee was on Keller's private calendar. It captured Renee saying she was not resisting and asking him to verify the file. Grant's first recorded command was "stop resisting," spoken after the first cuff had closed. There were no 3 warnings. County counsel responded within minutes. Grant could have spoken below the courtroom microphones, they argued, and a transcript was not proof of silence. Pike issued a second statement, saying the judicial record confirmed that Renee had been inside a restricted area and had reached for a sealed file. The contradiction was real, but incomplete. Renee understood the defense because she had used versions of it when reviewing trooper complaints. An official recording could establish what it captured, not every sound outside its range. Lena called again that night. Pike's legal office had demanded her stenographic machine, personal dictionary file, and synchronized backup audio for a courthouse security review. As an officer of the court, she reported to Judge Keller, not Pike. She had refused and placed the equipment in the judiciary's evidence cabinet. "He said refusal could cost me building access," Lena said. "Do not send me anything," Renee replied. "Follow Judge Keller's preservation order and document every request." "I already did." The next morning, Pike disabled Lena's courthouse access badge for an alleged security policy violation. Lena discovered the disabled badge when the employee entrance flashed red beneath her hand. She was scheduled to report a criminal calendar in 12 minutes. 2 court security officers offered to escort her back to the sidewalk. She called Judge Keller's clerk instead. Keller suspended the morning calendar and ordered Pike to explain why a judicial employee had lost access after obeying a preservation order. Pike responded that Lena had refused a lawful security request and retained county equipment during an active investigation. The judge corrected him in writing. The stenographic machine belonged to the judicial branch, and Lena's backup audio was part of the court record. Within an hour, Lena entered through the public doors under a temporary judicial access order. The confrontation delayed cases and forced Pike to defend his action before county counsel. It also created a dated record showing that pressure began immediately after Lena preserved evidence unfavorable to Grant. Renee learned about it from Vaughn while having the bandage changed. The swelling had decreased, but she still could not grip a pen without pain. "She should not be paying for my silence," Renee said. "Then stop treating silence as neutrality," Vaughn replied. The remark followed Renee into a secure conference with Judge Keller and counsel from both jurisdictions. Renee remained recused from the investigation, but she could decide whether to request partial disclosure of her own appointment materials. Keller proposed unsealing only the cover sheet and authorization page. The names of complainants, the security allegations, and the planned discussion would remain protected. Renee hesitated. Every disclosure taught officials something about the confidential review, yet withholding everything had allowed Pike to describe her as an intruder without contradiction. "Release the minimum necessary to establish lawful presence," she said. Nothing about the complainants. The unsealed pages showed that Keller had invited Renee to courtroom 4, authorized the clerk to bring her inside the rail, and directed that the meeting occur before the public ceremony. The authorization had been entered into the judicial calendar the previous afternoon, long before Grant touched her. The security desk had stamped the cover sheet when Renee arrived. Pike answered that judicial permission did not excuse a visitor from obeying a security officer. His defense narrowed, but it survived. Grant claimed he did not know about the authorization and had given 3 warnings that Renee ignored. That afternoon, counsel for a local television station contacted the court. Its camera operator had been recording the open proceeding from the rear aisle before the disturbance began. Unlike the cropped phone clip, the station's recording was continuous. The original memory card had remained sealed in the newsroom evidence cabinet after counsel issued an internal preservation notice. A duplicate was created, digitally fingerprinted, and delivered jointly to the court and county prosecutor. Renee watched it beside Vaughn on a monitor she did not touch. The wide angle showed the clerk gesture Renee forward. It showed the white attorney standing farther inside the rail with an unreadable temporary badge. Grant walked past him and approached Renee from behind. No warning appeared before his hand closed around her elbow. When the clerk lifted the blue file, Renee extended an open hand but never touched it. Grant pulled that hand behind her and fastened the first cuff. Only then did he say, "Stop resisting." The camera also captured the clerk raising the stamped authorization page toward Grant. He turned his face away before forcing Renee toward the side door. Renee felt no triumph. She watched herself choose composure while the room assigned meanings to her silence. She saw the instant Micah's classmates had repeated, now restored to the sequence that explained it. "Release it," she told the station's counsel, "but blur the appointment text beyond my name and authorization. The station makes its own editorial decision," counsel said, "but we will convey the request." The full recording aired that evening. Public reaction did not reverse all at once, but questions changed. Reporters stopped asking why Renee resisted and began asking why Grant ignored the clerk. A retired judge interviewed on air called Pike's account materially incomplete. The county prosecutor declined all 4 referrals, finding insufficient evidence that Renee knowingly entered without authorization, took a file, resisted, or impersonated anyone. The decision did not determine whether Grant had committed misconduct, but it removed the criminal accusation that had shadowed Renee's appointment. Minutes later, the Legislative Budget Office froze Pike's expansion request and demanded the underlying records for every claimed restricted zone breach. Renee expected Grant to be suspended. Instead, Pike reassigned him from public courtroom duty to the security records unit, giving him authorized access to the very incident files the legislature had just requested. The reassignment looked administrative until Renee examined the security platform manual included with Pike's budget application. Records unit officers could change incident categories, add supplemental narratives, and mark files ready for statistical reporting. They could not erase previous versions from the vendor's audit layer, but ordinary users never saw that layer. Grant now had permission to change what legislators would see. Renee could not direct the investigation, so she wrote a 2-page technical concern as the subject of the records and sent it through state counsel. The independent inspector assigned to the matter forwarded it to the Legislative Budget Office. Because Pike had certified the breach totals in support of a funding request, The office possessed authority to demand the underlying records and their audit histories. County counsel objected to a live system inspection, but agreed to provide a read-only export created by the vendor. The agreement preserved Pike's control over his network, while preventing his staff from selecting which versions to disclose. Grant responded through the union. He said the change from "did not display identification" to "refused identification" corrected an imprecise draft. He also argued that a security breach did not require a criminal conviction. A person could violate courthouse rules even when a prosecutor declined charges. It was a credible distinction, and Pike repeated it publicly. Renee read the statement with Lena Ortiz in Judge Keller's chambers. Lena's building badge remained disabled, so a bailiff had escorted her from the entrance. She placed her stenographic machine on the conference table, but kept both hands resting beside it. "I want the chain clear," she said. The machine never left judicial custody. The backup stayed in the court evidence cabinet. "I made the certified transcript from a working copy under the judge's order." Lena explained that courtroom 4 used 4 fixed microphones feeding a synchronized channel. Grant might have whispered beyond their range, as county counsel claimed, but his position near the clerk's microphone made 3 clear warnings, unlikely to disappear, while the rustle of Renee's sleeve remained audible. The television camera, recording from the opposite direction, supplied independent sound and image. "Neither record proves everything alone," Renee said. "Together they prove when his first audible command occurred," Lena replied. That was the moment Renee began trusting her as more than a custodian. Lena did not exaggerate what the evidence could do. She protected its limits as fiercely as its value. The vendor export arrived the next afternoon. It exposed a failure built into the courthouse reporting system. Once a supervisor approved a Category 4 event, the dashboard counted it permanently. There was no required field for prosecutorial rejection, judicial authorization, dismissal, or later exoneration. Pike's office could add those outcomes, but the breach total never adjusted automatically. Grant and Pike had treated that flaw as policy. Renee's case was already displayed as the newest high-risk breach, even though every referral had been declined. The dashboard summary used it to show a double-digit annual increase. Pike's funding narrative, updated after the arrest, cited an attempted sealed file removal by an individual falsely claiming police authority. It did not name Renee, but the description was unmistakable. Vaughn placed the document on Renee's desk. "They used your arrest to strengthen the application after the video proved the report false." "Not false in their system," Renee said. "Their system never asks how the case ended." That evening, Micah helped her replace the dressing on her forearm. The stitches pulled when she flexed her hand, but her grip was returning. "I watched the full video," he said. "I should have asked you before I believed the clip. You asked what everyone else was asking. I gave them an empty space and expected fairness to fill it. Are you going to keep doing that?" "No." The answer felt less like a promise to speak loudly than a promise to speak in time. Pike's attorneys soon filed an ethics complaint, accusing Renee of using state resources to punish a local officer. They requested an injunction barring state police personnel from contacting courthouse witnesses. The filing transformed her recusal into evidence of alleged interference. Vaughn's preservation requests, they claimed, were orders disguised as cooperation. The governor left Renee in operational command, but postponed the public ceremony again. Her first appearances as chief became legal briefings conducted behind closed doors, while Grant appeared on television in uniform beside a union attorney. Then the vendor released the audit layer. 6 minutes after the legislative office froze Pike's funding request, Grant had opened 12 older breach files. In 7, he added the same new sentence. Subject ignored repeated verbal warnings before removal. Every edit carried Grant's Authenticated Records Unit login and Pike's supervisory approval. The audit layer established who changed the files, but not why. Grant admitted making the edits and said Pike had ordered him to standardize incomplete reports before the legislative review. Pike described his approvals as routine supervisory work. Their defense turned suspicious timing into bureaucratic cleanup. The Legislative Budget Office expanded its request. Because the disputed totals supported public funding, analysts compared 2 years of Category 4 incidents with public court dockets, prosecutor dispositions, and judicial access authorizations. The records came from separate custodians: Pike's dashboard, the clerk's docket archive, and the courthouse access office. The first reconciliation found 43 claimed breaches. 26 had produced criminal referrals. Only 4 resulted in convictions for conduct occurring inside a restricted area. 11 were declined, 7 were dismissed, and 4 ended in minor offenses unrelated to the alleged breach. None of those outcomes had reduced Pike's dashboard total. Grant had initiated 19 of the 43 incidents. In 9, judicial records showed that the person had been invited or authorized to enter the disputed space. 7 of those 9 files now contained the identical sentence Grant added after the funding freeze. Subject ignored. Repeated verbal warnings before removal. The files included a black public defender sent through the wrong courtroom door by a clerk, a black grandmother called inside the rail to identify guardianship papers, and a white electrical contractor whose temporary access had expired while he repaired a ceiling fixture. The contractor was escorted out and recorded as an assistance call. The 2 black women were handcuffed and entered as Category 4 breaches. The comparison did not prove that every decision was racially motivated. It proved that Pike's statistics erased context and rewarded the most punitive classification. Renee reviewed the public findings only after they were released. Her recusal prevented private access, and the court's interim order required all contact with Lena to pass through counsel. The judge rejected Pike's demand for a complete witness contact ban, but the restriction isolated Renee from the person who understood the courtroom record best. Grant's union used that distance. Its attorneys suggested Lena had aligned herself with Renee before certifying the transcript. They emphasized that Lena's badge dispute gave her a personal grievance against Pike. On television, Grant said he had become a target because he enforced the same rule against a powerful chief that he would enforce against anyone else. He is turning equality into a shield, Vaughn said. Because the original act looks cleaner when he removes the sequence, Renee replied. She no longer waited for silence to be interpreted generously. With approval from the independent inspector, she held a narrow press availability concerning only her own conduct. She explained that she had protected a confidential judicial meeting, acknowledged that withholding her identity allowed misinformation to spread, and released her medical authorization so reporters could confirm the injury without accessing unrelated records. Rank did not make the handcuffing wrong, she said. The missing warning, ignored authorization, unequal treatment, and altered report did. Those facts would matter if I were unemployed and unknown. The statement changed the emotional center of the story. It also cost her. Pike's attorneys added the press appearance to their ethics complaint, arguing that Renee had prejudged Grant before administrative findings were complete. The state ethics office opened a preliminary review, forcing Renee to retain personal counsel and surrender additional transition emails for screening. At home, Micah found her sorting legal invoices beside the unopened ceremony program. Did speaking help? He asked. It helped people understand what I did. It gave their lawyers something else to use against me. Would you take it back? Renee folded the invoice. No. The deeper audit uncovered the system Pike relied upon. Category 4 totals generated quarterly risk scores. Higher scores supported overtime requests and supervisory positions. Pike's proposed response unit created a commander's stipend, a larger pension calculation, and 12 new posts under his control. Grant's recommendation for commander had been signed before Renee's arrest, but depended on the legislature accepting the surge as genuine. There was still a gap. The audit proved access, timing, financial benefit, and pattern. It did not yet prove Pike knew the added warning language was false. He claimed Grant possessed field notes unavailable to him, while Grant claimed he reconstructed warnings from memory. Without proof of what Pike reviewed before approval, their explanations could survive. The vendor's manual offered a possible answer. Supervisors could not approve a changed narrative from the dashboard summary. They had to open a red-line screen, review the added language, and certify that supporting material existed. The system logged each opening and certification, but Pike argued that the log could not show whether he had read the words carefully. The Legislative Committee scheduled a joint appropriations and public safety hearing. Pike requested that it be televised. Grant volunteered to testify and demanded that Renee appear under oath. The hearing notice listed Pike's funding request first and Renee's conduct second, framing the new chief as both witness and accused official. Pike's defense began before the hearing. His attorneys released the county security map showing that Renee's name had never been entered into the restricted access database. Judge Keller's authorization existed in the judicial calendar, but the two systems did not synchronize. At the security desk, Renee had received a general visitor badge because the clerk planned to escort her. Grant used the gap to recast the encounter as a communication failure. He said the clerk's gesture was ambiguous. Renee's hand moved toward a sealed file, and no visible credential established that she possessed lawful authority. The white attorney inside the rail, he explained, wore the same general badge but was personally known to him. The distinction sounded practical until Renee considered what it required. Familiarity protected the attorney, while uncertainty justified force against her. The union released Vaughn's preservation messages and Renee's instruction to retain Grant's radio traffic. Their attorneys called it evidence that the new chief had launched an investigation before county review began. They omitted Renee's next instruction not to request Grant's personnel file and to respect county jurisdiction. The ethics office expanded its review. Renee remained chief, but the governor's counsel directed her to avoid public discussion until after the hearing. Her command memorandum stayed frozen. Personal legal fees consumed money she had set aside for Micah's first year of college. When her stitches were removed, the physician found that the wound had closed without infection. Her grip was improving, though 2 fingers still weakened under sustained pressure. He advised several more weeks of exercises and warned that the scar might remain raised. Renee studied it in the clinic parking lot. Grant's lawyers had described the injury as superficial. The body remembered depth differently than a filing did. Preparation for the hearing took place through counsel-separated teams. Renee could review public records and materials provided to her as a witness, but she could not coordinate testimony with Lena. Judge Keller permitted Lena's machine and backup audio to be examined by a neutral court technician. The review confirmed that the certified transcript matched the synchronized recording and that no audio segment had been deleted. Grant's attorneys accepted the authenticity while preserving their main argument. Microphones could not record words never spoken near them. Pike attacked the statistics from another direction. He said the dashboard measured disruptions, not guilt, and that dismissed cases still consumed security resources. The repeated language, he argued, came from a reporting guide. Similar wording did not prove fabricated events. His office produced training materials containing phrases such as repeated warnings and escorted removal. Renee recognized the strength of the defense. A pattern could be suspicious without being corrupt. A copied phrase could be standardized without being false. Even an edited report could be corrected in good faith. The case would turn on sequence and knowledge. On the night before the hearing, Micah found Renee rehearsing answers at the dining table. Her lawyers had advised her to keep responses short and avoid conclusions about intent. "Are you going to say he was racist?" Micah asked. "I am going to describe what he did, whom he treated differently, and what he changed afterward. The committee can decide what the evidence supports. Can I come?" Her first instinct was to protect him from the cameras. That instinct had already shaped too many silences. "Yes," she said, "but you sit where you can leave if it becomes too much." The joint committee chamber was full before the hearing opened. Pike sat beside county counsel with binders arranged by colored tabs. Grant wore his dress uniform. Lena waited with counsel from the judiciary, her access badge still inactive. Renee entered through the public aisle with Micah and Vaughn behind her. Pike testified first. He described a courthouse facing rising threats and a security office forced to act with limited staffing. He acknowledged that prosecutor outcomes were absent from the dashboard, but insisted they were irrelevant to the workload. His proposed unit, he said, would prevent confusion like the encounter with Renee by improving communication. Grant followed. He spoke calmly and conceded only that he had failed to recognize Renee. He insisted recognition should not matter. I did not handcuff her because she was unknown, he said. I handcuffed her because her conduct created an immediate security concern. A committee attorney played the continuous television footage. Grant agreed that the clerk had raised a paper toward him. He said his attention was on Renee's hands. When asked why he passed the white attorney, Grant answered that he knew the man and understood his purpose. And Chief Holloway's purpose was not known to me. Did you attempt to know it before applying force? Grant paused. There was no time. The attorney froze the video on the clerk holding the stamped authorization page. 6 seconds passed between that moment and the first cuff. The committee did not treat 6 seconds as proof of motive, but the room's attention shifted from Renee's hidden identity to Grant's rejected opportunity to verify. Then the hearing reached the altered files. Pike testified that he had approved Grant's edits in a batch from the supervisor dashboard. He said he never opened the individual red lines and never saw the repeated warning sentence before it became part of the records. Renee looked toward the enlarged platform manual waiting beside the committee screen. Pike had placed his entire defense on an action the system did not permit. 3 weeks after the arrest, Renee took the witness chair. The committee attorney asked whether Pike's testimony could be tested without relying on assumptions about what he remembered. Yes, she said, but the limits must be stated first. A login does not prove what someone understood. An approval does prove what the system required that user to do. The committee displayed the version of the platform manual in effect when Grant edited the files. Renee explained the workflow she had identified before recusing herself. A supervisor began at the dashboard, selected one changed file, opened its red line, reviewed additions and deletions, and checked a certification that supporting material existed. Only then did the approval button activate. The supervisor returned to the dashboard and repeated the process for each file. There was no batch approval function. Pike's counsel objected that Renee was not the vendor. The committee responded with the vendor's authenticated configuration record and a demonstration prepared by its own technical staff. On the chamber screen, an analyst attempted to approve several files from the dashboard. The option did not appear. He opened one red line, but approval remained disabled until he checked the supporting material certification. The audit history then showed Pike's account opening all 7 red lines and submitting 7 separate certifications. The actions occurred across 9 minutes, not in one automatic batch. Could Director Pike have clicked without reading? The attorney asked Renee. Yes. Pike's counsel looked relieved. Would that make his testimony that he never opened the red lines accurate? No. Would it satisfy the certification he submitted? Not if he failed to verify supporting material. Renee refused to claim more. That restraint made the records harder to dismiss as vengeance. The committee placed the 7 altered files beside their original versions. None contained a contemporaneous note documenting repeated warnings. Grant's standardization explanation remained possible in theory, but it required memory to produce the same sentence across unrelated incidents months apart. In Renee's own case, the original report said she did not display identification. The amended report said she repeatedly refused. The television recording showed the clerk presenting the authorization before Grant turned away. Grant returned to the witness table. His attorney argued that the camera could not capture a quiet warning and that Renee's movement toward the file justified immediate control. Lena's synchronized audio was played next. It caught papers shifting at the clerk's station and Grant's equipment brushing Renee's sleeve. His first audible instruction still came after metal closed around her wrist. One recording looked from the rear, the other listened from the front. The certified transcript joined them through independent judicial custody. "Are you saying every unrecorded word is impossible?" Grant's attorney asked Lena. "No," she replied. "I am saying the report describes 3 warnings in a sequence where 2 independent recordings preserve movement and sound, yet neither contains one." The attorney turned back to Renee. "You could have prevented all of this by identifying yourself immediately, correct?" Renee looked past him toward Micah in the public row. "I could have disclosed my title sooner," she said. "That might have protected me. It would not explain why an unknown black woman received force, while a known white attorney with the same badge received trust. A lawful system cannot require status before it requires verification." She then walked the committee through the dashboard reconciliation. 43 incidents had been presented as proof of a security surge. 9 involved people with judicial authorization. Prosecutor and court outcomes were excluded. Renee's declined case remained counted. Grant's post-freeze edits strengthened 7 old files, and Pike certified each change while seeking money and a commander position justified by the total. Pike's counsel offered the final defense. The statistics measured workload, not guilt. Even mistaken incidents consumed staff time. That would justify recording the workload honestly, Renee said. It would not justify calling authorized entry a breach after the authorization was known, or adding warnings unsupported by the original file. The committee recessed. During the break, Pike amended his testimony through counsel. He now said he had opened the red lines but had not absorbed their wording. The correction protected him from one absolute statement and exposed another problem. He had certified support he could not identify. When the committee returned, it denied the expansion request and suspended consideration of the 12 new positions. It referred the version histories, certifications, and funding statements to a special prosecutor and the State Peace Officer Certification Board. Those referrals were not findings of guilt. County Council then announced immediate protective measures. Grant and Pike would be placed on paid administrative leave, their system credentials suspended, and the remaining security records preserved by an outside auditor. Lena's building access was restored under judicial control. The Ethics Office separately cleared Renee of using state investigative power, noting her early recusal and the council-routed preservation requests. It left one question about her press statement for later advisory review, but the threat to her command ended. As the hearing adjourned, reporters crowded the corridor. Renee did not declare victory. She stated that the evidence would now be tested through processes that Grant and Pike were entitled to challenge. Behind her, an outside auditor accepted custody of the breach database, while a county technician disabled Grant's final access token. The protective measures lasted longer than the news cycle. 4 months passed before the special prosecutor announced decisions. The outside audit had preserved every version of the breach files, confirmed the dashboard totals, and separated careless classifications from deliberate alterations. Grant was charged with falsifying public records and official misconduct for Renee's report and the 7 post-freeze edits. His attorneys challenged the audit export and argued that standardized language was not materially false. After the court admitted the vendor records and the 2 independent courtroom recordings, Grant entered a plea to 1 felony record falsification count and 1 misdemeanor misconduct count. He received supervised probation, community service, and a prohibition on public law enforcement employment during the probationary term. The certification board conducted its own hearing 6 months later. It did not treat the criminal plea as the only evidence. The board reviewed Grant's unequal enforcement, his refusal to examine the clerk's authorization, and his amendment from did not display to repeatedly refused. His peace officer certification was revoked. Pike was not charged with assault or with Grant's initial arrest. The special prosecutor found insufficient evidence that he planned the handcuffing He was charged with making false certifications in the funding records. Pike accepted a misdemeanor plea, repaid the commander planning stipend drawn during the application period, and resigned before his county termination hearing. His claim that he had not read the red lines spared him an intentional fabrication charge, but established gross negligence under county policy. The original referrals against Renee remained closed. Her ethics review ended with no violation. The advisory opinion criticized neither her press appearance nor the preservation requests, though it recommended written protocols when senior officials became subjects of investigations. State policy reimbursed the legal expenses she had incurred after following the required recusal process. At a public county meeting, counsel withdrew the statements that had described Renee as an unauthorized intruder and acknowledged that judicial permission existed before Grant approached her. The county did not admit that every security employee had acted improperly, because several had followed the preservation orders and later cooperated. Renee accepted that distinction. Repairing the record did not require turning an entire department into one villain. It required naming the decisions that had caused harm and the officials responsible for them. Renee's forearm healed over 10 weeks. Her grip returned fully after therapy, leaving a raised crescent scar that tightened in cold rooms. She stopped covering it with long sleeves, not because she wanted the injury to become a symbol, but because hiding it repeated the habit she was trying to change. Lena's access was restored permanently. The judiciary upheld her retaliation grievance and removed county security's power to disable court employees without immediate judicial review. Her stenographic machine returned to courtroom 4 after authenticated copies of the recording were deposited with the clerk and special prosecutor. She declined interviews and kept reporting proceedings in the same measured voice that had preserved Renee's first denial. The legislative audit corrected all 43 dashboard entries. Authorized visits were separated from genuine security violations, and prosecutor outcomes were attached without erasing the workload involved. 7 people received corrected records. 3 pending employment background checks were updated before the false breach designations caused further harm. The county abandoned Pike's response unit proposal. In its place, the courthouse adopted a narrower verification policy, developed jointly by judges, clerks, public defenders, prosecutors, disability advocates, and security staff. Restricted area invitations appeared on a shared verification screen that displayed only a visitor's name, escort, location, and authorization window. Confidential meeting subjects remained hidden. When information conflicted, officers had to contact the clerk before using force unless a specific threat required immediate action. The policy did not promise perfect judgment. It created a pause where Grant had refused one. Renee issued her delayed command memorandum after the county reforms were approved. It required state troopers to distinguish failure to display identification from refusal to provide it, and prohibited officers from rewriting one as the other. Supervisors reviewing amended reports had to identify the new supporting source and acknowledge the exact changed language. She included her own decision to remain silent in the training scenario, asking recruits to evaluate both her mistake and Grant's choices without treating rank as the answer. Micah attended the first class from the back row. Afterward, he asked why she had allowed instructors to criticize her. Because leadership that cannot survive an honest sequence becomes another cropped video, she said. The governor offered to move Renee's public ceremony to the Capitol. She chose courtroom 4 instead. The event was scheduled nearly a year after the arrest, following the completion of the criminal pleas and administrative findings. Renee did not want a spectacle staged as revenge, so Grant's name was not used in the program. On the morning of the ceremony, she arrived in the same Navy suit, with Micah and Vaughn beside her. Lena was already at her station. Judge Keller waited behind the bench. Reporters occupied the rear aisle, including the television crew whose continuous recording had restored the missing sequence. A new courthouse officer met Renee outside the rail. He did not recognize her immediately. Instead of guessing, he read her visitor badge, checked the shared screen, and called the clerk. The clerk confirmed that Renee Holloway was authorized to enter for a judicial ceremony. The officer stepped aside and said, "You may proceed, Chief." Renee remained where she was for one quiet second. "Thank you for verifying first," she said. Then she waited until the clerk opened the rail and invited her through.